we're going to now move on to the next session. I'm going to share my slides for that purpose. So now you should be able to see that we are in the interactive session and discussion of how to approach cases of discrimination. And then I invite all of you to participate because it's an interactive session. You don't have to, but if you have something to share, please do. How does it work? This section deals with practical aspects of AI and discrimination. So first, I will give you some examples and case studies, basically 2 examples, very short, very brief examples that you might have heard of, which makes the case easier because if you hear it for the first time, it always takes more time to get used to it. And it's really about your initial reactions. There's no right or wrong. Really, we want to hear from you what are your thoughts, your initial reactions without having that studied in detail. If you studied in detail, the exercise might be different. And so the point is really to learn how to approach a case of discrimination in practice. And afterwards, we have a short Q&A session. We're going to use Mentimeter for you. I will, in a moment, show you the QR code and the link to connect. But before we do that, I would like to briefly present the 2 cases. And then we do it case by case. First the first case, then the second case. And I will recall the main elements of the case so that everybody is on board and can contribute. So there are 2 examples in case studies. The first one is on AI recruitment, and the second one is on AI food delivery apps. So case 1 on AI recruitment. Imagine you have a company that uses an AI recruitment tool for pre-selection of future employees. The system is fully automated, but in principle, there can be an approval of human required, or in principle, a human is required to approve it. But if not, it's fully automated, the pre-selection. And what is pre-selected? It's the CVs are screened by the AI system, and it automatically selects the candidates who basically go in the next round. And how does that work specifically? The AI system uses publicly available data sets, so with all the biases and stereotypes that are floating in the internet, and also previous employment data. Just for you to know, in this company, nearly only men were working in this company. We're going to come back to the case, but that is the first case. Second case is on AI food delivery apps. You will have an AI-based app for food delivery. So if you want to order a pizza or another dish, it comes to your home. And the application ranks all of those who provide the food in accordance with their availability, their reliability, and so on. And so the important thing to know is that if you cancel a shift, you're ranked lower, and that impacts the way you basically make money. And so riders can cancel the shifts, but there is no possibility to give a reason for why they do it. For example, if they have to go to a gym class, they cannot give the reason. If they have to take care of their children, they cannot do that. And if they have to take care of an elderly person or trade union meeting, they cannot specify that. So these are the 2 cases. And now we're going to start with the AI recruitment case. I'm just letting some people in who join along the way. The AI recruitment case. So Mentimeter, for those of you who don't know how to use it, you have a QR code here that you can scan. Normally, you should be automatically redirected to the page. You can also go to menti.com and put the code, which is, I will read it out to you, 68416705. For those of you who cannot read the screen easily, 68416704 on menti.com, or you scan the QR code. So I let a little bit of time until the people, everybody can join. And I will now, just for your information, I will switch to I will share with you the Mentimeter slides where I'm going to get the results in real time. So I'm going to just change over one moment.
Fabian, if possible, do you have the link so that people who could access the chat could just click on the link?
Sure, I can post it
Because this way you don't need to worry that people see that you have on the screen the slide with the QR code, and everybody needs to be able to.
A brilliant idea. I will send it now. You will have it now in the link.
Beautiful, it's there.
So if you click on the link, you also should be automatically in there. So now I'm just sharing my screen.
Yeah, I'm there.
Can my colleagues confirm that you can see the Mentimeter? Mila, could you just confirm me that you see the Mentimeter slides?
I can
Okay,
see it.
perfect.
Yeah.
Okay.
There.
So basically now already the responses are coming in. Should there be a technical problem, please feel free also to post it in the chat if you have anything to share, whether it should not work for any reason, just so that we have a backup solution. So people are now sharing their first reactions to this potential case. And I just wanted to get really, you hear the case. I remind you, it's the case about AI recruitment, a company using an AI to kind of sort CVs, and the data sets used are previous public employment history and publicly available data. So you're all participating very well. There are many things coming in, and the beauty of the exercise is a little bit to have your first reactions, and you can already see by reading all of that you know your stuff very well, because all of these keywords reflect very well where the problems are. So collectively, I think we would be very easy to solve the case quickly. But this exercise is just basically to illustrate a little bit. Many of you know how to do it, but I think it's important to recall when we have a case of discrimination, how do we approach it? And I think the first reaction is always very important to see what is there. So we have already 60 responses. That's almost everybody who kind of replied, and all of them are pertinent. I will not make the exercise to read all of them, but just to tell you, it's good to see you either have very good knowledge already, or you followed very well, and you know where the problems lie. I think on this basis, we can 65, now nearly everybody is replying. I will now go to the next slide, and we're going to have the same approach for the second case. So just so that you know how it will work. So I will now go to the second slide, and you should now all be able to join the second question. I hope that's the case, and you can kind of answer the question, what could be the applicable legal framework? Now, after your first impression of to the case on AI recruitment, this is a bit more tricky one. So the answers are not coming in very quickly. There's some more people who would like to join. So you can reflect, if you think about this AI recruitment case, what could be the applicable legal framework? And it's really to say it can be non-discrimination law, it can be any law you can think about it.
Fabian, sorry, you need, just saying this to the participants, maybe click again on the link that Fabian has shared. And this would take you to the slide, what could be the applicable legal framework? Because currently, if you stay in the link that was before, you would see the previous question. What is your first reaction? And yeah, for some reason, it doesn't
want
move.
to refresh the browser, maybe.
Try, yeah.
Yes, I need to make it again because it disappeared. I need to make again the browser.
Apologies for this technological challenge. I assume it's automatically. Normally, it should be automatically. When I move the question, you should be able to see it.
Yeah, that's true. Okay, let me try. I click on the Menti link again.
Sorry, maybe you should click on present, and then we will be updated basically.
Thank you very much. I think that was the solution. Thank you very much. Now it should work. It's an interactive dialogue, so please, everybody jump in. If something is not working, we're going to also solve technical issues on the way. So the question again, applicable legal framework. So if now it hopefully works.
It works.
You could post AI Act, GDPR, non-discrimination law.
But how can I do it? How can I do it? I can see. Mentimeter.
The easiest is, Angelo Neves, if you just go click on the link again in the chat.
But where is the link?
Of the Zoom, and then you will be able to.
So I just posted the link just now.
It's in the chat. Okay, thank you.
Yes, this is the latest link. We will repost it.
Country profiling? No.
And it's
But
very
it's
interesting
okay.
to read someone said labor law. So that's also very interesting because obviously it's in the area of labor law. So always the exercise is a little bit to need to think what is the applicable law, because that's the starting point. Whether you are an equality body, whether you're civil society organizations or an individual who brings the claim, and in the end the court or the authority needs to see what is the applicable legal framework, what can I use? And it's not only non-discrimination law, it's not only the AI Act. We really need to look at everything to make our case well. And so it's good that I read labor law and equality lag laws. I think that is probably is, and the AI Act. So really that is the kind of the aim of that we think about all possible legal frameworks, because there are different tools in the legal frameworks and they mutually can reinforce and support each other. So that's very good. I think on this basis we have 47 questions. We can go to the next one. So I think I just click now like this and it should be much more smoother. And you should be able to address the next question, which is, what could be the legal discrimination problem? And that's a vote. It's just for you. In the case I described on AI recruitment, do you think it's rather direct discrimination, or is it indirect discrimination, or no discrimination at all? So that's just easy. You just need to kind of vote for one of the three options.
Fabian, can you please remind us and restate the definition for those colleagues who are not necessarily non-discrimination experts?
Yes, of course. Direct discrimination is basically if an employer would directly discriminate on the grounds of sex, religion, or another protected characteristics under e-law. So basically saying we don't want to employ men or women in our firm. And indirect discrimination would be if you have an apparently neutral behavior or norm that then indirectly leads to discrimination. For example, because you can prove it by statistics that somebody has been negatively affected without that being justified. That would be an indirect discrimination. So if it's not directly targeted towards one protected characteristic, but if it indirectly still affects them negatively, and this cannot be justifiable. So maybe this further explanations makes some people change or add, or again here the aim of this question is a little bit to flag that, as all of you know, under discrimination law there's direct and indirect discrimination, and sometimes it could be interesting to kind of try to find out whether it's direct or indirect discrimination. But the main point is here to say that under discrimination law everything is protected, be it direct or indirect discrimination. But why is it important to know the distinction? Because indirect discrimination can be justified. So if you have a direct discrimination, you don't need to do the exercise of justification. So it might be a lot easier to go for direct discrimination if this is possible. You just need to be aware in terms of information and proof and so on. What we heard also in the previous section by Patricia is it can be difficult to access the evidence. And so this is, of course, directly related to the case of discrimination you have. I think I'm moving on to the next question. And that is basically, how would you access the evidence to build a case? So again, I recall in our AI recruitment case, you have a company that is using an AI system for recruitment, and you now as an individual are affected. So for example, you are affected, and so you would fall under Article 85, 86 under the AI Act, or on the basis of non-discrimination law. You want to build a claim. So in order to build that claim, you obviously need to prove that something is wrong. So you need to access evidence. You need to know about it. You need to find the evidence somewhere, be it public sources, private sources. So the question is basically, how would, in this case, would you access the evidence and build your case? You can post anything that comes to your mind. I just want to basically pick your brains on this, how the mental process is. You have a suspicion of a discrimination case, and what do you do? So some people immediately make a complaint to the equality bodies or use transparency laws to access the information. I'm just maybe specifying the question a little bit. It's really, if you have a feeling that you're being discriminated, of course you can go directly to the equality body, but the equality body might ask of you a little bit more, because under discrimination law, very often you need to have a prima facie case. So you need to have some initial evidence that suggests that there is a case for discrimination. So now the answers are popping in. So I see many good things. Requesting information, documentation, making use of the rights. Of course, you can complain also to the equality bodies, and then they do their part. Very interesting answers. Test with different CVs. That's a very, very good idea. That's a very good idea. For example, Belgium equality bodies have such a power where they do this kind of mystery shopping where they test with different CVs, whether that leads to discrimination or not. That also exists in other member states. Ask the provider and the deployer. So there are many very good things. I think I'm seeing pretty much everything out there that have been hoping for. So these are among those answers you find here. These are typically the steps that you need to take. And very often, and that's something I wanted to also allude to, you don't even know that you have been discriminated. I mean, in my research, I discovered many private or public entities that use AI systems to do recruitment, and you have no clue that they use AI recruitment. You're not informed of that. And so sometimes this is the first thing you need to know about it, and then you need to request the specific information. Evaluate documentation, look at the outcomes. So there's very good answers here. So you have the good gut feelings how to get into that. And that's really an important step to gather the evidence to build a case. And one of the reasons why I was doing the exercise is also that you kind of be reminded that you use all national law possible, all the AI Act and discrimination law, all the rights that you can potentially use. And that is for individual civil society organizations or equality bodies to kind of gather the information to build your case. And the information or the rights you need are spread all over. So it's a little bit of fragmented scenario. So you need to be aware of that. I'm moving on to the next question. So thank you very much for your brilliant participation. That's very good. I want to finish this case with basically asking you, what are the challenges for building a successful case? And that can really mean anything. In relation to such a case, you have, let's say, a powerful company that is using this AI tool, and you contributed to the previous question. What, in one word or a few words, are really the main challenges that you think are out there? Getting the information. I think that's a very good starting point, and it's good that this is the first question, because in my view, this is really like the building block. If you don't have the information, you will not be even incited to do something, and you cannot build a good complaint. Company lobbying power, yes, certainly. That's interpretation. Interpretation is also very key, because sometimes you don't understand. So that's also the link to the first session of where Aaron taught us more about AI systems and how that work. The information alone doesn't help you sometimes, so that's very good. Transparency requirements, that was a lot what Trish talked about. No power to access information. Yes, there's certainly like an asymmetry of information between the companies and those who seek how to prove the discrimination. Perseverance, that's also... There's a lot of inspiration there. It's very good. I'm happy to read what you write. It's really good. We have make use of this collective power to solve any future cases of algorithmic discrimination. That's very good. Knowing the options, so it's a lot. Also, you need to be aware of your legal rights and all of that. So that's very good. Trade secret, I think that's very good, because a lot of stuff is IP protected. I mean, the big players, Amazon, Google, and you know all of them, they don't want to share everything with you, because then you have the recipe to make money. So that's IP protected, and you might need the help of courts. But there are possibilities out there, of course, to access the information. You know, probably the Volkswagen Dieselgate scandal. In this case, it was also IP protected, and the German courts granted access actually to some of the things. So even in that cases, there are possibilities to get to at least some of the information. Companies abroad, indeed, that makes it more challenging. But the AI Act, of course, I mean, applies and gives you right. If there's a contact with the EU market, then basically these companies need to comply with like other EU law. If you have competition law, you can also enforce that beyond the EU borders. Knowledge of lawyer in court. So again, we have 32 replies. Very good. No resources, I think, is also challenging. And that is challenging, of course, especially in the civil society world, and equality bodies, public bodies are often, and even courts are understaffed. So if you compare this sometimes to the power and human resources of big companies, that's of course an important point. So I'm very glad to read what you write, because these are many of the challenges that I think make this challenging. So I'm going to move on so that we don't lose too much time to the next case. So I will just recall. I will not change the slides so that that this Mentimeter keeps on working as it is. So the second case, I remind you, is the AI food delivery case. It's actually modeled on a real case, the Deliveroo case in Italy, if you know it. So you can also afterwards further look into what the court decided on the merits. It's about an application where you order your food, and if you are a Deliveroo rider, you can choose to refuse a shift. But what you cannot do is say that you refuse a shift because you have childcaring responsibilities or need to take care of the elderly. That's basically the lack of the application, and the court decided in a way I will not tell you now, but some might know the case. And so I again, without saying what the main problem is, I would like to kind of check what are your first reactions to this, that an application has not this possibility to say you refuse a shift because you have childcare obligations. So many people immediately know the key words: gender discrimination, straight to the point, no employee protection, power imbalance, work-life balance issue, potentially indirect discrimination, part-time job, bad design of the app. That's probably also true, although I have to say here, to the fairness of those who develop the AI apps, a lot of these things are not intentional. So sometimes you just don't think about it and you're just not aware. So it's not always the case that you do by design bad stuff, even though that's a possibility as well. But it's really to the point. Bad design, of course, you could provide for options that do otherwise. Working rights ensure high discrimination potential. Gender family status, exactly. And the AI system of this Menti application highlights the potential outcomes of the case: indirect discrimination in blue and gender discrimination in red. So somehow this is what the court decided to kind of solve the to kind of somehow reveal the mystery already. That's very good first reaction. So I think I'm moving on to the next slide. What could be the applicable legal framework? So I might have given away something, but maybe not everything. Again, the question, like in the first example, what legal frameworks are you thinking about if you think about this Deliveroo AI food apps? I don't want to say platform workers or click workers. But you might, recast directive, very good. Gender discrimination could be in this case. Labor law, obviously. Anti-discrimination law, AI Act, platform work directive. This is something I wanted to get out of you because that's relatively new. And without going into the details of the platform work directive, I just flag along the way that there are articles 10, 11, 12, I believe, that have something to say also on non-discrimination to kind of monitor the risk of non-discrimination. But this obviously only applies to platform workers. So that doesn't apply to all the cases of discrimination. So it's good to read that somebody posted platform work directive, equal treatment directive, caretaker law, yes, GDPR. Again, always think about GDPR if potentially there is an issue there. Anti-discrimination law, labor law, AI Act. So I think that's very good. Also the answers. Don't forget, the problem of the fragmentation is, in a way, you don't immediately think about the platform work directive, not for every case, because it's only applicable in the cases that fall under the scope. So it's very restrictive and narrow. And that's why I also brought you the second case, the first case more on a labor law issue that you think about. Well, there's labor law to kind of take into account, but also here that this kind of could be a platform work the case without going into the details whether that's the case or not. Labor legislation, surveillance of the high risk, yes. ECHR, also always think of the ECHR cases, of course, as inspiration, and also if all your judicial means are exhausted, it's always a good way to go, obviously, and there's a lot on evidence also by the ECHR. So 33 replies. I'm going to move on to the next question, as in the other case. If you can quickly flag whether you think it's indirect discrimination or direct discrimination or no discrimination at all. Because obviously it could be justified. It could be a very good reason for doing so. Oh, one person says no discrimination. I will not call out this person to explain why this is the case. But you can be a good lawyer arguing the case.
It's me who put no discrimination because I think this case is more related to labor rights without like that affects everyone. So I don't know which kind maybe of discrimination I can apply to this case.
Yes, I mean, thank you for your intervention. It's good that you flagged that, and of course you can. I mean, you can argue this potentially. I just refer you to the Bologna decision. We're going to share the reference. It's on my slide deck. The reference. The Bologna court decided that it was discrimination, so it was not justified. I believe afterwards the app was probably changed. So at least the court decided that this is a case of discrimination. I think it's difficult to argue that there is no discrimination. And it was
argued. It could be gender discrimination because like in many cases maybe a woman can have different like more commitments that prevent them for fully accepting any all like every case of delivery, because maybe they can have a baby, they can
yeah,
so
I mean,
probably
yes, I think thank you very much for your contribution. I think there are many things you can argue, and these elements are potentially very useful if you argue this case in court. I just maybe don't want to expand the discussion so much that we can move on. But of course, in this case, there would be different treatment between men and women, because statistically, many more women have caring responsibilities. And as the case law of the Court of Justice kind of found on multiple occasions, this is an indication for a clear case of indirect discrimination, unless this is justified. And so I will share with you afterwards the case. You can have a look at it. Of course, I mean, lawyers also argue different things potentially in the case, but just to tell you, in this case, it was relatively straightforward, at least what the Bologna court said. So I think on this we're going to move on, but thank you very much for this point. I mean, you can always argue everything. So that's the beauty of it, of the law. If you find the good arguments, in this case, it was decided in that way. So most of the people are vouching for direct discrimination. Indirect discrimination. The case for direct discrimination, of course, if you use something that is exclusively a link to women, then you have always a good case to say this is a direct discrimination. In this case, it was indirect discrimination. But always think about all the options. So we move on to the next one. And again, the same question: how would you access the evidence to build a case? Now you know how this works. Do you think there are any peculiar challenges how to access the evidence in this case? If you have an app, you again have a big company. In this case, it was Deliveroo, I can say, because it was a public case. So you have a big player called a surveillance body. That's very good and effective. They hopefully immediately investigate the case. It is obvious. And I remind you, this is a case from 2019 that has been decided in 2020. So some time has passed since. So this is also should be on the radar screen of each and every equality body and civil society organization, those who are interested in it, because it has been quite some years. And it's a good way to find also new cases. Request info on design, that's very good. I think journalists, it's very good that this is mentioned, are a very good source, because you find a lot of cases where it's not clear whether the legal threshold is crossed or not. And so very often it's first journalists who kind of discover cases. For example, the famous Amazon case was also reported by Reuters many years ago. And that is a good source of information in turn for civil society and equality bodies and others kind of inspire themselves and to see whether there are similarities, or to kind of compare. That's good. Statistics is always good. Test the app, read grounds of discrimination. I think that's a check that definitely needs to be done. Instructions for use, maybe something is specified there. Trade unions are also a very good source, and AI design information, documentation, all of this info should be requested. A testing of the systems, obviously, we heard about it, Article 7073, and Trish mentioned it also in her presentation. It's always important to also test, and the deliverers log. It's also good, I mean, in terms of evidence, if you get access to that, and that's very good. And of course, complaints to equality bodies and courts can make that a way harder case that you really have also the access rights, contrary to you or via your lawyer just asking to receive the information. So I'm moving on, that we don't lose too much time, and just briefly ask, what do you think are the challenges for this case, for building a successful case? Do you see anything that is particularly relevant that you would like to flag here? So again, business interest, employer hiding info, getting the evidence. I think these are the main challenges indeed. Trade secrets. No information or complaints. I think you understand where this is going. Tech understanding. The tech understanding is obviously a point, because even if you receive the information, it's again a challenge. You need to kind of understand also, and the lawyers on the side of the complainant, but also on the side of, for example, the equality body or the court, obviously needs to understand the tech that has caused this discrimination. So again, having resource issue, as is written here, is a good challenge. And be brave, I think, is something, working in this area, is something that we all need in order to successfully build claims. And this is also shown by the fact that there are not so many cases out there. It's only slowly growing, and there's probably a very high number that is kind of undetected. And previous court decisions can always be helpful, so it's important to look out for other cases. I completely agree with that. Conscious of the time, I will move on to the end of this presentation. So I'm